It is your favorite auditor, audit them, the one who encourages you to audit them. It is your favorite auditor, audit. Audio's testing, audio's clear. Alrighty. Tonight we're going to be reviewing the State of Illinois Judicial Inquiry Board. Inquiry. We're on the government website here, illinois.gov, and we're looking at the Code of Judicial Conduct. Let's zoom in here. Alrighty. Everybody please hit the thumb up upon entry. We're going to be reviewing some very important information. We have to stay informed. And with that being said, let's go ahead and begin. Sound check is clear. Number one, an independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based upon the principle that an independent, impartial, and competent judiciary, composed of judges with integrity, will interpret and apply the law. Thus, the judiciary plays a central role in preserving judicial justice and the rule of law. Sound test fail. Judges with integrity will interpret. Alrighty, it says, I'm not sure why it says 0. We have a few people in here. Let's see here. Oh yeah, we got a few people in here. If you could confirm that you do hear the audio. I do hear the audio very clear. Audio is very low. Alrighty, check now. So with that being said here, so let's start over here. I did turn up the volume just a bit if somebody else could confirm. We are looking at the Code of Judicial Conduct, the State of Illinois, Preamble, and Scope. Number one, an independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based upon the principle that an independent, impartial, and competent judiciary composed of judges with integrity will interpret and apply the law. Thus, the judiciary plays a central role in preserving justice and the rule of law. Inherent in the rules contained in the Code of Judicial Conduct Code are the precepts that judges, individually and collectively, must respect and honor the judicial office as a public trust and strive to maintain and enhance confidence in the legal system. Number two, judges should maintain the dignity of judicial office and avoid both propriety and the appearance of impropriety in their professional and personal lives. Right? In their professional and personal lives, they should aspire at all times to conduct that ensures that the greatest possible that their conduct ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. The audio is very low. Let's check a setting here. Okay, we turned up the mic here. We did crank up the mic. If somebody could go ahead and confirm. Alrighty, moving on to number two. Judges should maintain the dignity of judicial office and avoid both. Yep, we read that one. Alright, moving on to number three. Number 3. The code establishes standards for ethical conduct of judges and judicial candidates. The code is intended to guide and assist judges in maintaining the highest standard of judicial and personal conduct and to provide a basis for regulating their conduct through the Illinois Judicial Inquiry Board and the Illinois Courts Commission. Good now. Number 3. The code establishes, here we are at number 4. The code governs a judge's personal and judicial activities conducted in person, on paper, and by telephone. Again, let's read that one over. The mic needs to be louder. This is the loudest the mic goes. Here's another feature here. Alrighty, yeah, I could boost it up from here. Let's see. What about now? What about now? What about now? Can you confirm with me? We could upscale the mic here even more. Upscaling the mic now. Upscaling the mic now. Alrighty, what about now, folks? Microphone has been upscaled. Well, here, let me turn on the secondary mic. Give me 1 minute here. Let me turn on the secondary mic. Alrighty. CC Hope, how's it coming? Alrighty. We are testing the mic now. What about now? What about now? What about now? Testing, testing, monitor, monitor, testing, testing, monitor, monitor. Testing, testing, monitor, monitor. Alrighty, we'll go ahead and continue here. Here, let me double check on this side. Monitor, monitor. Yeah, it should be better now. Testing, testing, monitor, monitor. Alright, beautiful. So we'll go ahead and continue. Now it's kicking. Great. Hey, Planet Jesus, Auditor Shield member, how's it going? Number 4. Now there's an echo. Here, let me check this out. Auditor Shield member, how's it going? No, now it sounds fine. It sounds fine. It just had a slight echo. The code governs a judge's personal and judicial activities conducted in person, on paper, and by telephone, or other electronic means. A violation of the code may occur when a judge uses the internet, including social network sites, to post comments or other materials such as links to websites, articles, or comments authorized by others, photographs, cartoons, jokes, or other words or images that convey information or opinion. See what it says here? It's forbidden. It's forbidden, basically, for judges to have an opinion, whether on clock or off clock. So violations may occur even if a judge's distribution of a communication is restricted to family and friends and is not accessible to the public. Judges may carefully monitor their social media accounts to ensure that no communication can be reasonably interpreted as suggesting a bias or prejudice, and ex parte communication. The misuse of judicial power or prestige, a violation or restrictions on charitable, financial, or political activities, a comment on a pending or impending case, a basis for disqualification, or an absence of judicial independence, impartiality, integrity, or competence. Alrighty. Hey, Planet. Thank you so much for doing that, man. Do you have a channel? Do you have content on your channel? Yeah, let me click on your channel here. Let's see. Alrighty, yeah, we got a few people in here. These comments are not coming in too fast. So let's go ahead and continue. Guys, I am going to get to the comments. Please, everybody leave comments. I'm going to get to them as soon as we get to the next point here. Let's just go ahead and continue. We got to knock this out. All right, moving on to number 5. I will get back to all the comments. Number 5, the code consists of 4 canons. 4 canons. Numbered rules under each canon, and comments that generally follow and explain each rule. The policy and scope and terminology sections provide additional guidance in interpreting and applying the code. The numbering of the code is patterned on the American Bar Association Model Code of Judicial Conduct 2010, reserving numbers for provisions not incorporated in Illinois. Number 6, the canons state principles of judicial ethics that all judges must observe. Although a judge may be disciplined only for violating a rule, the canons provide important guidance in interpreting the rules. Where a rule contains a permissive term such as may or should, the conduct being addressed is committed to the personal and professional discretion of the judge or candidate in question, and no disciplinary action should be taken for action or inaction within the bounds of such discretion. Number 7. The comments that accompany the rules serve 2 functions. First, they provide guidance regarding the purpose, meaning, and proper application of the rules. They contain exemplary material and, in some instances, provide examples of permitted or prohibited conduct. Comments neither add to nor subtract from the binding obligations set forth in the rules. Therefore, when a comment contains the terms must or shall, it does not mean that the comment itself is binding or enforceable. It signifies that the rule in question, properly understood, is obligatory as to the conduct as issues. Let's go ahead and take a pause here before we get to number 8 here. Let's go through the comment section. The phone is freezing up here. Let me reset this one and click on that one. Alrighty. So KT says, yeah, they need a revisit. Alrighty. Hey, Planet, what do you have any content using that packet that you have, the Wisconsin binder? I would like to see that one. Let me know. Number 8. Second, the canons combined with the comments identify aspirational goals for judges. Aspirational goals, right? To implement fully the principles of the code as articulated in the canons, judges should strive to exceed the standards of conduct established by the rules, holding themselves to the highest ethical standards and seeking to achieve those aspirational goals thereby enhancing the dignity of the judicial office. This is good language. Number 9, the rules of the code are rules of reason that should be applied consistent with constitutional requirements, statutes, other court rules, and decisional law, and with due regard for all relevant circumstances. The rules should not be interpreted to impinge upon the essential independence of judges making judicial decisions. Impinge. Let's look that one up. What is that, a hinder? Impinge.
Here's the definition of impinge. Have an effect or impact, especially a negative one.
Alrighty. So you said you went to the Jacksonville City Hall, and they were all in compliance. And in what part were they in compliance? What was the scope of your audit? Number 10. Although the black letter of the rules Number 10. Although the black letter of the rules is binding and enforceable, it is not contemplated that every transgression will result in the imposition of discipline. Whether discipline is imposed should be determined through a reasonable and reasoned application of the rules, and should depend upon factors such as the seriousness of the conduct, the fact and circumstances that existed at the time of the conduct, the extent of any pattern or improper conduct, whether there have been previous violations, and the effect of the conduct upon the judicial system or others. Number 11. The code is not designed or intended as a basis for civil or criminal liability, nor is it intended to be the basis for litigants to seek collateral remedies against each other or to obtain tactical advantages in proceedings before a court. Effective 2023 terminology. The first time any term, alrighty, here's the definitions here. As defined, contributions means both financial and in-kind contributions such as goods, personal or volunteer services, advertisings, and other types of assistance, which if obtained by the recipient otherwise would require a financial expenditure. Oh, beautiful. Yeah, there we go, man. We got somebody in Wisconsin State checking on the checklist that we developed. Yeah. That's a good one, man. That one, Wisconsin has a nice extensive writing there. So we're going to go ahead and continue here. De minimis, in context of interests pertaining to disqualification of a judge, means an insignificant interest that could not raise a reasonable question regarding the judge's impartiality. Hey, I wanted to ask you guys a question. Is the audio all good now, and does it keep lagging, or is it good? KST says you have to visit the library. Yeah. KST, do like Planet Jesus there, Planet Rock Jesus. He got the Wisconsin binder, and now he's going and checking on government the right way, bro. KST, I no longer need you to do suggestions. I need you to use the utensils. Right? You see how good Jesus is, how he came in here? It's not just the username, Jesus. It's the Spirit saying, hey, look, now is the time. Alrighty, domestic partner means a person whom another person maintains household and intimate relationship other than a person's legal spouse. Economic interest means ownership. All right, we're gonna scribble through this. Fiduciary, means ownership of more than one de minimis legal or equitable interest. Fiduciary includes relationships such as executor, administrator, trustee, or guardian. Impartiality, and impartiality, if I'm reading that correctly. Wait a minute. Impartiality, and impartiality, right? Means absence of basis or prejudice in favor of or against particular parties or classes of parties, as well as maintenance of an open mind in considering issues that may come before a judge. Impending matter is a matter that is imminent or expected to occur in the near future. Alrighty, well, let's skim through this. Integrity means probity. I gotta look that up too. Fairness, honesty, uprightness, and soundness of character. Judicial candidate, that's a good one. Soundness of character. Now, when the officials are saying your FOIA training is superior. Judicial candidate means any person, including a sitting judge, who is seeking selection for or retention in judicial office by election or appointment. Let's read this one over here. Judicial candidate means any person, including a sitting judge, who is seeking selection for or retention in judicial office by election or appointment. A person becomes a candidate for judicial office as soon as such person makes a public announcement of declares or files as candidates with the election or appointment authority, authorizes or, where permitted, engages in solicitation or acceptance of contributions or support or nominated for election or appoint to office. Yeah, we gotta know this language. Hey, mouth breeder, good to see you in here, man. Defining the stuff. KST, take notes, bro. Don't talk about other topics we're not talking about, bro. KST, I want you to do like some other people say, read the room. Let's focus on what the topic at hand here. But no, Planet came in right, man. He says, I encourage you to others join Auditor Shield. In order to get AT's info. Well, it's really the info out there, but you gotta put in the work, man. You could do it yourself. Yeah, that's true. Let's go ahead and continue here. Knowingly, knowledge, known, or knows, mean an actual knowledge of the fact in question. A person's knowledge may be inferred from the circumstances. Law encompasses court rules as well as statutes, constitutional provisions, and decisional law, decisions made, case law. KST says you have Illinois FOIA binder. Yep. Okay, members of the judicial candidate's family, right, means a spouse, alrighty, member of the judge's family, alrighty, must, this is a good one, must, when used in rule, imposes a mandatory duty on the judges to comply with the rule. When used in a comment, the term does not mean that the comment itself is binding or enforceable. It signifies the rule in question, properly understood, is obligatory as to the conduct at issue. Right, there it is. It's an obligation. It's a mandatory duty. Everybody knows what must means. Non-public information means information that is not available to the public. Non-public information may include but not limited to information that is sealed. Oh, that's cute. By statute or by court order, or impounded or communicated in camera, and information offered in grand jury proceedings, pre-sentencing reports, dependency cases, or psychiatric reports. See Rule 3.5. Alrighty. Well, that's a cute thing that they speak about sealed items in camera, on camera. So now the question is, if they discuss matters that are become sealed, do they have it on camera, and is that camera accessible? Even though they claim non-public information, via subpoena and... Alrighty, pending matter. Pending matter is a matter that has commenced. Matter that has commenced, right? It's commenced, it happened. A matter continues to be pending through any appellate process until final disposition. Alrighty. Let me look at the comments here for a minute. KST said any mods have links. KST, all you have to do is navigate on my channel, locate either a section that says members or a section that says join, and search for Auditor's Shield. Sign up for a month and email me, and you'll receive the Illinois binder. Planet says, you inspired me because we need to be more than just photographers going to the government buildings. There needs to be a focus on holding them accountable. This has given me more of a focus. Man, I love that, bro. I love that. No Puff Daddy, no Diddy, no homo. But that's inspiring. That is inspiring. John De Nicola, question is, can you get it unsealed? That's a good question, John D. The $ at the bottom too. Yeah, there's a $ on the membership. Sign up now early while it's hot, because once we put the app out, I'm gonna transfer you to the Tribe channel, where you're gonna have to put in a sufficient dumpling in there. So I'm not gonna say too much, but I'm telling you folks, sign up now early, if need be, if interested. And thank you so much, Planet Rock, for you inspired me, man. The people inspired me, because the comments and the feedback say, hey, you know what? The way to go, the real right way to go, is to hold government accountable. And the thing that you have your name Jesus in your chat is saying that, hey, you know what? Walk the good walk. If these defalcators, if these government officials want to cast aspersions and show themselves off, at least what you have in your hand is a mirror there, right? And what you have in your binder is an actual standing. KST says they don't care, they threaten and manager. Well, you gotta flicker, man. You gotta build up your knowledge. Personally solicit means a direct request made by a judge or a judicial candidate for financial support or in-kind services, whether made by letter, telephone, or other means of communication. Political organization means a political party or group sponsored by, affiliated with a political candidate or principal purpose, which is to further the election or appointment of candidates for political office for purposes of yada yada. Public election includes primary and general elections, partisan elections, nonpartisan elections, and retention elections. Require. Oh, and they define shall. That's going to be scary. Require. When used in the context of the rules prescribing that a judge require certain conduct of others, means that a judge is to exercise reasonable, that's the key word, discretion, and control over the conduct of those persons subject, and that's cute, those persons subject to the judge's discretion and control. That's beautiful. That's a beautiful writing there. Shall, here's the good one. Shall imposes a mandatory duty on a judge to comply with the rule. Right? Now, who's kicking off that mandatory compliant? Who's teaching? It got to be the proper persona litigant. It got to be the people, right? So shall imposes a mandatory, because the judge is the public servant. The man, he is the facilitator. Shall imposes a mandatory duty on a judge to comply with the rule. When used in a comment, the term does not mean that the comment itself is binding or enforceable. It signifies that the rule in question, properly understood, is obligatory as to conduct at issue. Because the term shall appears passim, we got to define that. Its first use in a rule is not marked with an asterisk. Right. Alrighty, let me see some of these comments here. What's normal just clicked in. KST says 25 for 4 Illinois binder. Not a bad deal. Yeah, sign up, and email me. You'll get that one expedited because Illinois is already prepared and updated. Planet Rock, I appreciate you, man, for signing up. You'll have a lifetime update, man. Anytime anything new comes in, I'll shoot it over to you. I'm a believer too. 24 years as a private investigator, a bit of history of police corruption against him, says Planet Rock. All that combined has given me a heart to hold government accountable. Yeah, man, you know what? Hey, it's got to be done. It got to be done. And it is an amazing and inspiring thing that more people are aligning to actually see, the truth, reality. Man lies, women lies, the camera doesn't. Man lie, women lies. The job description doesn't. Shall, alrighty. Third degree of relationship includes the following persons: great-grandparents, grandparents, parents, uncle, aunt, brother, sister, child, grandchild, great-grandchild, nephew, and niece. See Rule 2.11. Beautiful. Here we're moving along to canons. We're moving along to the canon. Alrighty. T-Dotter is saying, are you going to be hosting a members-only Q&A with guests? Yeah, yep, we are. And, well, you must be more informed than the cops. Yeah, definitely, man. If they want to pull a fast one. KST says, do you have the Illinois law about disorderly conduct and trespass? Yeah, KST, that is included in the Illinois binder. Get yours today. John D says, I have a question about the ILCS code on body cams. Why are the departments editing conversations with the people who are on traffic stops? I'm not sure why they're editing those. I need to see it case by case. If they edit something, maybe when you say edit, you're talking about redact. If they do, under Section 9A states that they have to provide the citation and clear and convincing evidence, language from the FOIA Act, why they are editing something or redacting something. That's under Section 9A. But then again, it got to be case by case, If you could give me an instance, John D. Planet Rock says, look it up, print them out, also find them case law in your state if you can. Yeah, it's a no-brainer. The binder, you don't have to pay the $25 to get my binder, and half of it goes to YouTube. You could look all this stuff up by yourself. But one thing that I do is I do the work for you. I have it prepared for you. And as time goes on and as things update, you're always going to be consistent with the knowledge. So it's a good start to get the binder, because all it is a quarter. You receive the printout. You go to the dollar store, buy a dollar printer, a dollar binder, and you put in this packet. I'll send you the packet to put in your binder. We're going to get into the canons now. Let me just reset my phone because it keeps resetting. Here we go. Alrighty. Canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety in all the judge's activities. And that there's a reason why the judge in Georgia got removed. The main, the chief judge got removed off the bench because she had an opinion. So, comments. Number 1. An independent and honorable judiciary is indisputable and indispensable for creating and preserving public trust and confidence in legal system. This court shall be construed and applied to further this objective. That's a good one. Rule 1.1. Compliance with the law. A judge shall comply with the law, including the code. Rule 1.2. Promoting confidence in the judiciary. A judge shall act at all times in a manner that performs public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Comments. Number 1. Public confidence in the judiciary is eroded by improper conduct, and that's a good one, and conduct, and creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. If anybody has any questions, please leave it in the comment section. Number 2, a judge should expect to be the subject of the public scrutiny. Oh, that's cute. That might be viewed as burdensome if applied to other citizens, and must accept the restrictions imposed by the code. Number 3, conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines the public confidence in the judiciary, because it is not practicable to list all such conduct. The rules necessary cast in general terms. The rule is necessarily cast in general terms. Number 4, judges should participate in activities that promote ethical conduct among judges and lawyers, support professionalism within the judiciary and legal profession, and promote access to justice for all. That's a cute one. Number 5, actual proprieties include violation of law, court rules, or provisions of this code. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, impartiality, temperament, or fitness to serve as a judge. Fitness. I don't think that judge is fit to be on that bench. Alrighty, number 6. A judge should initiate and participate in community outreach activities for the purpose of promoting public understanding and confidence in the administration of justice. In conducting such activities, the judge must act in a manner consistent with this code. Rule 1.3. Avoiding misuse of the prestige of judicial office. Prestige. A judge shall not misuse the prestige of judicial office to advance the personal or economic interest, and that was defined, of judges or others, or allowed to do so. Comments. It is improper to use or attempt to use the judge's position to gain personal advantage or differential treatment of any kind. For example, It would be improper to allude to judicial status to gain favorable treatment in encounters with traffic officials. Similar, a judge must not use the judicial title in letterhead. Oh, that's cute. Emails or any other form of communication, including social media networks, platforms, to give an advantage in conducting personal business. An advantage in conducting personal business, right? Number 2, judges may provide a reference or recommendation for an individual based on the judge's personal knowledge. I'm going to have to read this one again. Judges may provide a reference or recommendation for an individual based on the judge's personal knowledge. Stationery may be used for references and recommendations. So this one is saying, number 2 is saying that they can give you legal advice, but they can't. Number 3, judges may participate in the process of judicial selection, except as otherwise prohibited by Canon 4 or restricted. Canon 2, a judge shall perform the duties of judicial office impartially, competently, and diligently. Rule 2.1, giving precedence to duties of judicial office. The duties of judicial office as prescribed by law shall take precedence over all judges' personnel and extrajudicial activities. Extrajudicial. I gotta make a song about that one. Comments. Number 1, to ensure that judges are available to fulfill their judicial duties, judges must conduct their personal and extrajudicial activities, including their use of social media or participation on social network platforms, to minimize the risk of conflicts that would result in frequent disqualification. That's a cute one. Frequent disqualification. So let's read this one over. To ensure judges are available to fulfill their judicial duties, judges must conduct their personal and extrajudicial activities, including their use of social media or participation on networks, to minimize the risk of conflicts that would result in frequent. Alrighty. Number 2, although it is not a duty of judicial office unless prescribed by law, judges are encouraged to participate in activities that promote public understanding of and confidence in the judicial system. This is nice because we could do inquiries with the judges to see what programs they partake in, what activities they assisted or promoted for the public confidence. Number 3, judges are reminded that Article 4, Section 13b of the Illinois Constitution of 1970 requires that a judge shall devote full time to judicial duties. Oh, wow, I like that. C3.1 concerning a judge's ability to participate in teaching. Right. The judge has to have an ability to teach. Rule 2.2, impartiality and fairness. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comments. To ensure impartiality and fairness to all parties, a judge must be objective and open-minded. 2, although each judge comes into the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. Number 3, good faith errors of fact or law do not violate this rule. Oh, that's a good one. But Chief Judge, I know I'm just an associate judge, but I used good faith and it was an error. So number 4, it is not a violation of this rule for a judge to make reasonable accommodations consistent with the law and court rules to ensure pro se litigants the opportunity to have their matters fairly heard. And I believe in Rule 63, where they repealed that one in 2013 is where they used to use the language propria persona instead of the word pro se. So I did a chart, side-by-side chart, earlier today of a pro se, the difference between a pro se litigant and a propria persona. And some already know that as the pro se subjects himself or herself to court slash bar rules, and it gets extensive, but we'll discuss that at a later time. Rule 2.3, bias, prejudice, and harassment. Bias, prejudice, and harassment. Rule 2.3. A judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. B. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, or harassment based upon sex, gender, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socio-economic status, or political affiliation, and shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. C. Proceedings before the court shall be conducted without manifesting or biased. Oh, wow. Without manifesting, while the judge and the attorney talk in the elevator. Without manifesting bias or prejudice or engaging in harassment based upon attributes including but not limited to gender, yada yada. D. The restrictions of paragraph B and C. The restrictions of B and C are, do not preclude to judges or lawyers from making legitimate reference to listed factors or similar factors when they are relevant to the issue. Alrighty. A judge shall not retaliate against those who report violations of Rule 2.3. So let's go back to Rule 2.3. What was that? Yeah. Rule 2.3 was prejudiced or biased. So F. A violation of Supreme Court of Illinois non-discrimination and anti-harassment policy is a violation of this rule. Let's read F over. A violation of the Supreme Court of Illinois non-discrimination and anti-harassment policy is a violation of this rule. Okay, that one needs brainstorming. However, let's continue. If anybody has any comments, please leave them in the comment section. Let me address comments now. Peoria, Illinois. Are you referring to, John D? Yeah, that's a good one, Planet. If you need to tweak it a little bit, you can. Uh, it opens up a new aspect for people to work, on holding government accountable. Then I break down the legalese so it could be understood in plain English. T. Dot says, who has the authority to hold them accountable to these canons? John D. says, Judicial Review Board. Gabriel is laughing at a comment. Alrighty. Yeah, fictitious requester is an oxymoron. Well, let's go ahead and continue here. Let me just zoom out for a little bit here. See, this is a long haul here. This is a long haul. We could knock this out real quick if we keep fighting. But let's go ahead and continue here. We are at... Oh, yeah. Rule 2.6, ensuring the right to be heard. We were going to get to that one. Alrighty. So we were at here biased at 2-3, and we're at the comment section in biased. Alrighty. A judge who manifests bias or prejudice in proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. What? Planet Rock says 25 years ago, he was attacked while protesting abortion. His daughter filmed it while in court, county. The judge looked away. Oh, while you were explaining it. That video sense was looking at the scene, did not, the video sense, you were looking at the screen, did not notice the judge said, I didn't see anything. Later, after that hearing, his kids told him that the judge wasn't looking at the video. Well, yeah, you know, nobody cares. There's one deputy sheriff in Florida that made, you know, he made it clear. He said, nobody cares. You know. What's normal says, how is it possible for a man to be pure in thought, a judge is another without bias? Alrighty. Well, here we're going to continue on here. Number 2, examples of manifestations of bias or prejudice. Oh, wow. Examples of manifestations of bias or prejudice include, but not limited to, epithets, right? Slurs, demanding nicknames, negative stereotypes. Slurs, stereotypes, attempted humor, attempted humor, that's cute, based upon, so what law school did you go to? Attempted humor based upon stereotypes, threatening, intimidating, or hostile acts, suggested of connections between race, ethnicity, or nationality and crime, and irrelevant references to personal characterizations, including even facial expressions and body language, can convey to parties and lawyers in the proceedings, jurors, and the media, and others' appearance of bias and prejudice. A judge must avoid conduct that may reasonably be perceived as prejudiced or biased. Well, this is telling us is a judge has to make a facial expression to be recused. Alrighty, let's go ahead and continue. This is a beautiful one. Let's read this one over. Number 2, examples of manifestations of bias or prejudice include, but not limited to, epithets, slurs, demanding nicknames, negative stereotyping, attempted humor based upon stereotypes, threatening, intimidating, or hostile actions, suggestions of, this is like those commercials in the middle of the night in the 90s and 2000s of medicines, prescriptions, but there's side effects. So here this is teaching people the law. Examples of manifestations of bias or prejudice include, but not limited to, epithets, slurs, demeaning nicknames, negative stereotypes, attempted humor based upon stereotypes, threatening, intimidating, or hostile acts, suggestions of connections between race, ethnicity, or nationality, and crime, and inherent references to personal characteristics, including facial expressions and body language, can convey to parties and lawyers in the proceedings, juries, and media, and appearances of bias, prejudice, and a judge must avoid. So all this is just saying is that, yes, the judge is an honorable person, the judge is a public servant, and the judge has a duty to serve the public. Let's carry on. Number 3, harassment is verbal, nonverbal, or physical conduct that denigrates or shows hostility or aversion towards a person based on characteristics or classes identified in paragraph B and C. All right. Harassment based on sex includes, but not limited to, sexual advantages, requests for sexual favors, and other verbal, physical contact of sexual nature that is unwelcome. But I like number 3 though, where it says harassment is verbal, nonverbal, or physical conduct, right? So it's verbal or nonverbal or physical conduct that denigrates or shows hostility. Alrighty, carry on. Number 5, Rule 215 requires judges to take appropriate action when they learn of another judge's misconduct. In considering this obligation, judges should recognize that failing to inform court leadership of an incident may allow a pattern of misconduct to go undetected. Judges may have a specific reporting obligation under Supreme Court of Illinois for non-discrimination and anti-harassment. What I need to know if they have an obligation to inform court leadership of any recusal that they may receive or any disqualification letter. Number 6, retaliation is an adverse action. Retaliation is an adverse action performed directly through others that would deter a reasonable person from reporting or participating in an investigation of conduct prohibited by this rule. The duty to refrain from retaliation includes retaliation against former or current court personnel. Alrighty, before we go into external influences on judicial conduct, let's look at the comment section here. This is a good read, man. This one is a good one. Alrighty, yep, everybody's up to date here in the comment section. Log out, log in. Alrighty, let's get right back to it. Rule 2.4, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. Right? A judge shall not permit family, social, political, financial, or other interests or relationships to influence the judge's conduct or judgment. C. A judge shall not convey or permit others to convey the impression that any person or organization is in position to influence the judge. Comments. An independent judiciary requires that judges decide cases according to the law and facts, without regard to whether particular laws or litigants are popular or unpopular with the public, the media, the government officials, or the judge's friends or family. Confidence in judiciary is eroded if judicial decision-making is perceived to be subject to inappropriate outside of influences. Yeah, it's eroded. It breaks down. And the key word if, it tells you why. Competence, diligence, and cooperation. A judge shall, and this is, let me slow everybody down further here. You see, this is why you need channels like this. Tribe, 2 hours ago, Tribe did a reading on affidavits. Back to back, I opened up a panel and do a reading. You see, this is what we need more of. 3 days later, or I just finished doing a reading. Here comes What's Normal, opening up a panel and doing a reading of CFR codes. It's sickening and disturbing that more people are not doing this type of information, being informed on this. Planet Rock says judges can constantly violate about all these rules. Yeah, man. Yeah. This is disturbing. But this is just some language. This is just some Planet Rock. There's many more to it. Like you said, there's federal rules, there's statutes, there's many more to it. The T-Dot says, even enough people agreeing on the same subjective truth of a system by their own resources causes them to regard the system as an objective fact. like I said, Tribe would just finish doing a reading, important reading, stuff that's not read anywhere. Once he's done, I open up a panel immediately, back to back. Alright, let's go ahead and continue here. Rule 2.5, competence, diligence. So what I'm saying here, basically in layman's terms, is the work cannot be stopped. The work has to continue. The work has to keep going. The information has to be studied. You know, this is just the beginning. Competence, diligence, and cooperation. A judge shall perform judicial and administrative duties competently and diligently. B, a judge shall cooperate with other judges and court officials in administration of court business. Number 1, competence in the performance of judicial duties requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary to perform a judge's responsibilities of judicial office. A judge should seek the necessary documents, time, court staff, and resources to discharge all adjudicative and administrative responsibilities. Number 3, prompt disposition of the court's business requires a judge to be punctual in attending court and expeditious in determining matters under advisement, and to take reasonable measures to ensure that court officials, litigants, and their lawyers cooperate to achieve that end. Right? Number 4, in disposing of matters promptly and efficiently, a judge must demonstrate due regard for the rights of parties to be heard and to have issues resolved without unnecessary cost or delay. That's a cute one. A judge shall monitor and supervise cases in a way that reduce or eliminate diluting practices, avoiding avoidable delays and unnecessary costs. Yeah, this is the Planet Rock said a great comment there. Judges constantly violate almost all of these. Rule 2.6, ensuring the right to be heard. A judge shall accord. This is the language they got they repealed it. They used to have this language in another section. Rule 63. A judge shall accord every person who has legal interest in a proceeding or the person's lawyer. See, they added the word lawyer. In the one before they repealed this one, it did not say lawyer, and it had language of pro se and propria persona. A judge shall accord, now they added the word lawyer. A judge shall accord to every person who has legal interest in a proceeding or that person's lawyer the right to be heard according to the law. B, a judge may encourage parties to a proceeding and their lawyers to settle matters in dispute, but a judge shall not act in a manner that coerces any party. See, they shortened down, they diluted. As a matter of fact, look how contradictory they are. Here they diluted the principles of this portion here, really. The principle of this section, ensuring the right to be heard of the people, this one was way more extensive. This was about 2 paragraphs long. Look how they shortened it down and included the word lawyer. That's for a different topic. What I'm going to do is I'm going to go to the law library one of these days, and I'm going to receive from them the one that was repealed. And if I could get that one certified, even better. Comments. Well, maybe they get into it here, but we got to match the old one. There was a reason why it was repealed. Number 1. The right to be heard is essential component to a fair and impartial system of justice. Substantive rights of litigants can be protected only in procedures protecting the right to be heard are observed. The judge plays an important role in overseeing the settlement of disputes, but should be careful that efforts to further settlement do not undermine any party's right to be heard according to the law. Number 3, judges should be mindful of the effect settlement discussions can have not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality. Despite a judge's best efforts, they may they may be instances where information obtained during settlements discussions could influence the judge's decision making during trial. In such instance, the judge should consider whether disqualification may be appropriate. Rule 27, responsibilities to decide. A judge shall hear and decide matters assigned to judge, except when disqualification is required. That's cute. That's cute. Comments. Although there are times when disqualification is necessary to protect the rights of litigants and preserve public confidence in the independence, integrity, and impartiality of the judiciary, judges must be available to decide matters that come before the court. Unwarranted disqualification may bring public disfavor to the court and to the judge's personally, the dignity of the court, the judge's respect for fulfillment of judicial duties, and a proper concern for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid case that present difficult, controversial, or unpopular issues. So this is all it's saying is you, the people, use this disqualification against the judge, but they can't disqualify themselves because it may be difficult or controversial. Alrighty, before we get to decorum, demeanor, and communication with jurors, man, this is a good packet. Good one. Nobody hold judge accountable. Yeah, God is the ultimate judge. God is the ultimate judge. We're going to get into decorum, demeanor, and communication with jurors. Take a quick break here, drink a sip of water. Meanwhile, we're going to be looking in the comment section. Everybody, please let me know if you have any questions about what we discussed so far. And if there's anything you'd like to point out to me, I'm going to take a drinking water break for just a few seconds here. Thank you. Yeah, well, the thing about it is that if judges are public servants, the question is that you folks' question was who holds them accountable, right? Who holds judges accountable? Well, if they're public servants and it's the duty of the people to hold government accountable, government staff accountable, then now the question is, do you believe the people it's the duty of the people to hold them accountable, or are they able? Is the people able to hold government accountable? Is there channels? Is there remedy for a person to hold, make sure that the judge is acting according to these canons and rules? Planet Rock says, I'm an hour north of Madison and from Chicago and know the area extensively. I'd like to get together sometime. Yeah, I usually don't do the meetups, Planet, you know what I'm saying? But, if definitely, if we'll definitely talk behind closed curtains and you see what's up, man. You are a member, so it really tells me that you are a serious one. In a way, I gotta believe everything anybody tells me, but then again, you gotta be like, you know, cautious who's all out there and shit like that. Uh, Mouth breather saying, "Are these national judicial codes? What's the scope of these codes of conduct?" This is Illinois bound. Illinois Code of Judicial Conduct. But it's very similar. It's very similar nationwide. Because if you think about it, the whole nation has counties and similar language. Yeah, Planet, let me see some of your work, man. Send me some of the videos that you have, with that checklist. All you would have to do is just send me a link to the video. It does not even have to be public or private, it could be unlisted. Uh, then again, you know what I'm saying? When you want to go out there and audit, sometimes it's better to stay solo because um, sometimes it gets too hectic when there's more than one person. Yeah, Planet Rock. God bless you, man. If anybody's seeking knowledge, and thank you for letting me know that. I'll definitely send over as much info as I can for that Wisconsin binder to be updated, and I'll focus a lot in on the police encounters and stuff like that. I'll dig deeper into the um, Wisconsin Freedom of Information Act, even though I know it does have real great portions. I read that one about a year, 2 years ago. I got it somewhere on my channel. We read Wisconsin, and it's, I think, it's unlisted right now. But I definitely keep that in mind and see if I could cook up some things tailored uh, to I got the solo thing right. AT, come closer to the mic. You are far away. Alrighty, here we are getting back on duty. We are getting back on duty. Yeah, definitely Planet. That's what it's all about, man. That's what it's all about. My whole idea about it is that this, quote unquote, community, or not, but what it should be is these comment sections and these subscribers and these usernames that are back and forth in these auditing videos should be discussing FOIA requests that we submitted and FOIA requests that we received a week later. These should be topics and conversations that are a start to come together, get on these you know shows and discuss these things. And if we want to, and what we really can do, is we could focus in on case by case study. If there's somebody got violated and somewhere in one county, then we'll come together and we'll discuss it, whether on an open show live or behind the closed curtain on a phone. It makes no difference. The thing about it is that we can utilize the tools that we do have, and one of them is the Freedom of Information Act to receive uh, evidence and whatever we're trying to uh, Alrighty, let's see. T Daughter saying the only lady was intimidated by your very large binder. Yeah, the college manager. Well, I don't know if it was the large binder that intimidated her or the lack of knowledge of the contents within the binder that intimidated her. Alrighty, back on duty. Rule 2.8 Decorum, demeanor, and communication with jurors. A. A judge shall require order and decorum in proceedings before the court. B. The judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and other subjects to the judge's direction and control. Good on calling the customers subjects. C. A judge shall not commence or criticize jurors for their verdict other than in a court order or opinion in a proceeding. Comments. Number 1. The duty to hear all proceedings with patience and courtesy is not inconsistent with the duty imposed by Rule 2.5 to dispose promptly of the business of the court. Judges can be efficient and businesslike while being patient and deliberate. Deliberate. Number 2. Commanding or criticizing jurors for their verdict, including on social media or other social platforms, may imply a judicial expectation in future cases and may impair a jury's ability to be fair and impartial in a subsequent case. Number 3. A judge may meet with jurors who choose to remain at the completion of a trial, so long as the judge does not make any remarks that would adversely affect the judge's impartiality. Alrighty. Hey, signing out, Planet Rock Jesus. Thank you for coming in here, man. Good night. I got to open up the shop. Alrighty, God bless you, man. Yeah, keep up the good work. Send me a link if you like to, and I'll review the checklist. Alrighty. Well, with that being said, yeah, I think we're gonna shut it down here. Yeah, we're gonna leave off at ex parte communications for the next one. Anyways, thank you guys for coming in here. We did a little over an hour show here. Well, yep. Thank you guys again for coming in. We will pick this up at a later time. Copy page 2. And until the next one, the one who encourages you to